Contributing writer Jake Fogleman and I answer Reload member questions on the Supreme Court, concealed carry, and Congress. That and more on this episode of the Weekly Reload Podcast.
No, the devil's got no hold on me.
All right, welcome, ladies and gentlemen, to another episode of the Weekly Reload Podcast. I'm your host, Stephen Gutowski. I'm also the founder of the reload.com, where you can head over and sign up for our free weekly newsletter today if you want to keep up to date with what's going on with guns in America from a sober, serious perspective. And of course, you can buy a membership if you want to get exclusive access to hundreds of pieces of analysis and reporting that you will not find anywhere else. One of the other benefits of being a Reload member is that you get to ask the questions when we do our Q&A episodes of the podcast, which is exactly what we're doing this week. It's Thanksgiving holiday weekend, so we are not doing a news update, but we are doing a full interview. I mean, we're kind of mashing them together because with me I have, of course, contributing writer Jake Fogleman. Welcome back to we're kind of backwards from what's normal because normally you're hosting and I'm the guest on the news update, but this week I'm hosting and you're the guest on our interview podcast where we're interviewing each other, I guess, about the questions, or I guess more like the Reload members are interviewing us and asking us a series of questions. So it's good to see you, Jake. I hope we're filming this shortly before Thanksgiving, so hopefully you have some fun plans coming up. And I'm headed up to Pennsylvania myself with my wife to be with some family during the break. And yeah, let's get rolling. I know we got a lot of questions, actually, a good number of questions, a lot of detailed questions, a lot focused on the Supreme Court too, I would say. But we can start off first with Richard, one of our members, and we're going to keep people, anonymous here, but just use first names so people can know that we're answering their questions. But he starts off with a little bit of a compliment. He said, a warm thank you for creating the Reload. When I first discovered the Reload, I knew it was exactly what I was looking for and what was missing from all the other YouTube channels and reporting mediums I follow. I wanted a realistic analysis and forecast of what was happening in the Second Amendment space by people who understand firearms, supported the Second Amendment, but could maintain the necessary clinical detachment to stay objective. So that's kind of a nice thing off the bat. Thank you, Richard. That is a pretty good description of what we try to do here. And it's always nice to start with an ad, I guess, at the beginning of the show. But his question concerns the Supreme Court, which a lot of these do. And he wrote, do we know, perhaps through attorneys who have clerked for justices, why the court has been moving at such a glacial pace to accept cases in general? And he said, this is especially evident with the slew of assault weapons bans, but also other Second Amendment cases. So he's wondering why the slow pace of these Second Amendment cases, it seems like just cases in general, and then in particular gun or Second Amendment cases, because he worries that that allows a lot of lower courts to kind of go their own way and not really follow closely the standards set by the Supreme Court in Second Amendment cases, especially the landmark cases like Heller and Bruin. And that's been obviously a common complaint from Second Amendment advocates for, going on 15 years now. That his question is basically like, why is the court particularly maybe slow generally, but also particularly slow on the Second Amendment? What are your thoughts on that?
Yeah, so it's an interesting question. We don't know. I don't think anyone knows for sure. It's one of those things we talk about all the time with the Supreme Court. We don't have some crystal ball that we can look into the justices' brains and see what they're thinking on a given issue. But there are people that at least have informed opinions and watch the court and can try to read tea leaves as best as they can to get an idea. I don't think they know exactly why, but there is an interesting sort of paradox going on with the court because, as Richard points out, yes, this particular court has been taking fewer and fewer cases each term overall. Just in general, people that track the courts have come to this conclusion as well, is that just an overall caseload terms, they're taking much fewer cases than they have traditionally. But sort of paradoxically, they are taking more Second Amendment cases and gun cases than they have pretty much ever historically too. So I get why it's frustrating that maybe they're not taking the big ticket items that the gun rights advocates really want them to take. But you do have to kind of acknowledge that in the last few years, we've seen them take already 2 Second Amendment cases since 2022. They've taken other gun-related cases that maybe weren't decided on Second Amendment grounds, but were at least related and things that gun rights advocates do care about. And then they're taking 2 more this year. It's the first time in U.S. history that they're taking multiple Second Amendment cases in the same term. So they are, in fact, taking more Second Amendment cases. It's just that perhaps it's not the ones that folks really want them to take.
Yeah, and look, I think that the Roberts Court, as you laid out there, is just a pretty slow-paced court generally. They don't take a ton of cases compared to some previous courts, under different chief justices. But why that is, we don't know for sure. They have made much more aggressive use of the shadow docket, right, of emergency docket, than other courts have in the past, and that's become a point of controversy. But really not in Second Amendment cases. Not often Second Amendment cases they're doing that. But yeah, we had Jonathan Adler on a couple months ago. I think it was actually the second to last time we had him on. We discussed this at length. This idea of like what's going on with the Supreme Court. Why did they not get more involved in holding lower courts to account when it comes to Second Amendment issues? Because that's been a common complaint from Second Amendment advocates for a very long time. Then the lower courts will sometimes, especially places like the Ninth Circuit, right, will rule in ways that the court that seem pretty contradictory to how the court laid out its test or what have you. And the court itself, at least some members of the court, especially Clarence Thomas, right, have noted this. That's in Bruin. They talk a lot about how the lower courts were treating the Second Amendment as a second-class right. And it's been something that Thomas has been saying for forever now. And it's not entirely clear why they choose to take a slower pace. I mean, I think that often what you'll hear from the justices like Amy Coney Barrett, I think there's a whole book on this, right? She just did a book tour, not necessarily directly addressing the Second Amendment question, Second Amendment cases, but more generally the court's philosophy, which is that they take these things very seriously and they want to be extremely careful about how they approach each issue because they recognize that it's going to sort of echo through the centuries. Is the opinion that you'll often hear them articulate, especially the conservative justices. And so it's not a very satisfying, I think, answer if you're a Second Amendment advocate, because the truth is right now that they actually are going pretty fast comparatively to where they had been recently. And there is some reason, this is one of the reasons these 2 cases, while that's not a lot of cases, obviously, and they're not necessarily ones that I think most experts believe will have kind of land out of them, that they're not necessarily going to be extremely impactful in a practical sense. The biggest positive takeaway I've seen from pro-gun scholars who look at this is the idea that they are taking more cases and that maybe they will take even more. We had David Kopel, who's one of your colleagues at the Independence Institute, on the show a couple weeks back to discuss really the big picture question of the Supreme Court's approach to the Second Amendment in this term. And he said, they might take even more cases. It's not, they haven't done it yet, but it's entirely possible that maybe they'll start taking more. We've seen Justice Kavanaugh allude to the fact that they're going to take more and take one of the biggest questions still undecided out there, which is the legality of these assault weapons bans, which is something we'll get into a lot more as the show goes on. But why doesn't the court get more upset when the lower courts appear to contradict its rulings on the Second Amendment? Well, it seems like they're not quick to undo all kinds of stuff. I mean, they do have to deal with a lot of cases, right? It's not while we may focus on one issue that they decide, they have to decide every issue that's at conflict in the federal courts, and so they just seem to take maybe a slower pace generally, which is not, I'm sure, very satisfying. But they don't appear to approach things with the idea that they're being um, offended by how the lower courts treat some of their precedents. They doesn't appear to speed up their movement based on that.
Yeah, certainly. It's a good question, though. Next one comes to us from Reload member Bob. Similar, it's about the Supreme Court as well. He says, it's interesting in the wake of the Mexico versus Smith & Wesson decision that was a unanimous decision. And he notes that Justice Elena Kagan, who is a Democratic appointed justice, wrote the majority with a statement pertaining to AR-15s as, quote, the most popular rifle in America. He notes some other details about what the court's recently done, where the court rejected a petition that requested an overturning of the Obergefell ruling, which was the ruling that established gay marriage. And he says, the question is, do you think the Supreme Court is getting consensus for these Second Amendment cases by holding to precedent for liberal priorities? In other words, by making deals? And so I don't know, what do you think about that? Do you think there's horse trading going on behind the scenes with the liberal justices to get sort of a consensus on these cases?
That's a good question. I don't think so. I just don't think that the liberal justices have that much pull, or that they're doing anything quite as straightforward as like, we'll rule this way if you rule that way. In certain cases, I think what you see more often are like, they approach these cases individually, and certainly I think if they can find a common ground, often I think Roberts wants as much unanimity as possible in most of these cases, although obviously this court has been willing to buck even the most controversial precedents, like Roe v. Wade, as was mentioned in Bob's question. And they have been willing to split along ideological lines in big and important cases. But I do think Roberts has traditionally been concerned about the court's perception and the getting as much unanimity as possible on these opinions. And that's where you might see efforts by some of the liberal justices to influence how a case is going to go if they know it's going to go in a certain direction, and there's something that they can find common ground on, like the Vulu case, for instance, NRA v. Vulu, not a Second Amendment case, but a gun-related case with the NRA as a plaintiff. But there was a pretty easy path to getting to a unanimous decision. Same thing with Smith and Wesson case against Mexico, where it was not a Second Amendment case necessarily, but had big implications for the gun industry, and but also the underlying legal question was something that they could find common ground on, and then you have the opinion written by Kagan or Roberts instead of Thomas or Alito. There's probably a bit of strategic litigating that goes on there behind the scenes, where like if the liberals can get a case more focused on some area of wide agreement, that's they will perhaps be more willing to join an opinion on that basis. And Roberts and maybe some of the other justices on the right prefer that to a 5-4 or 6-3 decision.
Yeah, no, I think that's a good point. And there's actually been some interesting reporting to that effect out of the New York Times and a couple of other outlets as well, specifically as it pertains to Justice Elena Kagan, reportedly anyway, from people that evidently are speaking on background and off the record to these reporters, that's sort of how she sees her role in this conservative dominated court, is to, where possible, try to negotiate behind the scenes on individual cases, not the horse trading where you rule one way on this case in exchange for ruling on separate case, but behind the scenes to do what's the meat of the ruling where we can come to a consensus, and maybe we limit the ruling to just that instead of a big broad sweeping ruling where we might lose some of the liberal justices. And to your point, Chief Justice John Roberts does, I think, like it when the court can look as unified as possible whenever it can.
And that, I think, can also go back to the previous question of like, why aren't they taking up as many Second Amendment cases as gun rights advocates might want them to? Well, it seems like if you look at some of the recent rulings, especially with how many concurrences have been were issued in Bruin and Rahimi, maybe there's just not as much agreement among even the conservative justices on the extent of Second Amendment protections or the proper way to do the Bruin test. There's still a bunch of unanswered questions that even justices like Barrett, have talked about in their have talked about in their concurrences that remain unresolved. And so there may be less of an appetite to take those cases in the first place if they don't have a pretty clear consensus between at least a significant majority of the court on what the outcome should be. So as far as ideally judges should just be looking at the law and their judicial approach to interpreting the law and just apply that in every case, but in real life, yes, I think politics come into play, but probably not as substantially as some people would think. I don't think it's horse trading like I'll rule this way if you rule that way. It's probably more like you just described there of like, well, if we can find some common ground on this particular case, maybe one justice has to back off a bit on what they agreed to, or and maybe one justice has to move a little in one way. I think that's more where you see it. Although again, certainly, a lot of it is just sort of tea leaf reading more than anything, because we don't know what happens in those discussions behind closed doors the vast majority of the time.
Sure. And then he has a part 2 question where he asks, assuming the court does someday strike down blue state assault weapon bans as violating the Second Amendment, he asks, what if these states ignore that decision and continue to resist, either by keeping the laws in place or by tweaking them to try and find loopholes in the court's decisions? Basically, what is the sort of recourse there? He asks, could the Trump administration prosecute state governors as civil rights violators, for instance? What do you think, what recourse is there in such a scenario?
I mean, I think it's unrealistic that they would keep their laws in place. We haven't really seen that attempted anywhere. You could just look at Bruin, for instance. Every state that was impacted by Bruin's decision declaring may issue permitting laws unconstitutional, they got rid of their old laws. But what the second avenue mentioned there is the much more realistic one, which is what we have seen is states will get rid of the laws that the court finds unconstitutional, and then they'll just pass a law that moves right up to the edge of constitutionality, and maybe even steps over it, and then you have to litigate that again, which is what's happening right now with Bruin, right? With the Supreme Court now is deciding the Hawaii case about the so-called vampire rule, right? That was a Bruin response law that was said, okay, well, if we can't do may issue permitting, we'll try some other restriction. We'll have a lot of, pretty high bar for what training you need to get a permit. We'll have much more restrictions on where you can carry a gun with a permit, which is what the vampire rule does. Like, we're gonna reverse the defaults where it says publicly accessible private property is now off limits to people with permits unless they get permission through like a posting of a sign or something, which is the opposite of how it has been traditionally. And so that's what I think is much more likely. That's what we've seen. And the solution is more court action. The Trump administration could intervene in some ways and actually has, right? The DOJ has started doing civil rights investigations. The civil rights lawsuit that we've seen against Los Angeles County Sheriff's Department is a reaction to the Bruin the Bruin ruling, right? The claim is that they're intentionally slow walking permits and that they're charging too much money, and that is a result of the ruling in Bruin from the Supreme Court. So yes, you could see both. What I think you would see is what we've seen after Bruin, which is states that don't want people to carry guns will then try to find a new way of restricting that they believe they can defend in court. That goes, up to the line of what the previous unconstitutional law was. We've seen that all over the place. We saw that in D.C. a bunch of times after their laws were struck down. And then yes, the federal government could go in and file civil rights lawsuits against these jurisdictions that try those sorts of tactics, and that is probably what would happen in an assault weapons ban. In the event that assault weapons ban was found to be unconstitutional, you probably would just have states adapt. And although I think they'd probably go more towards the Colorado model.
Yeah.
Right?
That's what I was going to bring up is, I don't have too much to add to what the federal government could do in response to sort of what they've already been doing in the carry cases. But yes, the only caveat I would say is I would anticipate should something like an assault weapon ban be struck down, I would expect them to do much more of the permit to purchase lane that, like you said, Colorado has recently adopted. And that could be a little bit of a tougher thing to police just because of what the court has already established about permitting in its Bruin decision and the concurrences, where it seemed to imply anyway that permit to purchases are okay because it put it on par with permitting for carry, for instance. So it could be a little bit of a trickier thing to try to police that, but obviously that's all hypothetical. We don't know yet.
Yes. So we have another question, another Supreme Court question. This is from Paul. I'm going to call him Paul 1 because we actually have two Pauls who've written in with questions for this episode. And so Paul 1 says, living in a gun-restricted state, when do you think an assault weapons ban case may be taken up by the Supreme Court outside of the suggestion from Justice Kavanaugh that there may be one taken up in the next term or two? I just don't see the light at the end of the tunnel. Meanwhile, more and more states are moving in the direction of assault weapons ban implementation, and the inferior courts routinely find in favor of the bans, openly flouting Heller and Bruin. Well, first off, we'll just start with that. What do we think the timetable is? Do you have what's your thought?
Yeah, I've written about this before. Is again, tea leaf reading. There's no guarantees. The Supreme Court gets to do whatever it wants to do, right? That aside, that disclaimer aside, there is something that poses, I think, a pretty good opportunity for it to be to fulfill Kavanaugh's sort of promise in the next term or two. And I think another Reload member has a question that's related to this, but that is the New Jersey assault weapon ban case. I wrote about this at the time, the fact that the Third Circuit is hearing that challenge en banc. And the Third Circuit is the first of these courts to hear an assault weapon ban case that actually has a majority of conservative appointed judges. Now, that's not to say that that's equally automatically is a foregone conclusion that, more conservative appointed judges means they're going to rule X way. But you have to say that the odds are better in that scenario than they have been in every other circuit, which have upheld bans and thus kept it from being a circuit split. So if you get this Third Circuit ruling that strikes down New Jersey's ban, suddenly you have a circuit split, and that's much more of a tantalizing proposition for the court, who really sees its job as resolving discrepancies amongst the lower courts, because they're the court of last resort, and that's sort of their job. So I will say that there is that avenue in the next term or two, as Kavanaugh suggested.
Yeah, and I think that's the right read. I mean, of course, we were previously the talking point had been, well, they haven't. The court doesn't seem to want to take up Second Amendment cases that aren't at the merits stage and haven't gone through full, vetting at the lower courts yet, because there were a number of opportunities where they could have taken up like requests for preliminary injunctions, and they decided not to. And we got some statements from the justices to the effect of, we're going to let the lower courts, do their thing before we get involved. But then obviously we had the case out of Maryland where it was at the merit stage, and that is the one that Kavanaugh, where you had three justices who dissented on the denial of cert, and then you had Kavanaugh issue a statement explaining the reasoning, perhaps, of the justices who, or at least the conservative justices who denied cert in the case. And that's where he said essentially that there's still perhaps more percolation needed, although he certainly seemed to have his mind made up, because in the statement, he more or less says he thinks the assault bans are unconstitutional, and he had previously signed on to, or he previously issued a dissent in what's called Heller 2, which was a challenge to DC's assault ban that was unsuccessful, where Kavanaugh himself had already concluded that he thinks assault bans are a violation of the Second Amendment. But yeah, so now the thought is, well, maybe they're waiting for a circuit split because the lower courts hadn't produced one of those yet on an assault ban, but we may soon get one, and maybe that is what they're waiting for. And certainly I think it gives more weight to a cert petition, because, as you said, that is the role of the Supreme Court to decide these lower court disputes. Paul also asks if there's any sort of levers that gun rights advocates can use to kind of raise the urgency for the court here. And I don't know there's anything you can do beyond just win at the lower court win this Third Circuit case. And that'll, like you laid out, probably raise the urgency for the court to do something if there's an unresolved split at the circuit level.
Yeah, no, I don't disagree. Yeah, just keep filing lawsuits and hope that you win one is pretty much the best you can hope for. The court as an institution is deliberately designed by our Constitution to sort of be insulated from public pressure and attempts to put urgency on the court. And that's why they have things like lifetime appointment and, et cetera, all the Article 3 protections in the Constitution. So there really is I don't think there's really any way to instill a sense of urgency other than to just continue filing court cases and hope that one is appealing to them.
Yeah, exactly. And then we have a question from Paul too, that veers a bit from the Supreme Court topic that we've been talking about, just to break things up a little bit. He asks, a concealed carry reciprocity mandate in Congress is a frequent topic of conversation. He said a recent email from Everytown for Gun Safety told me that passing that would allow, quote, a violent criminal to carry a concealed gun in my community. This implies that there are states in which one can get a concealed carry permit despite having a violent criminal record. Is that true? And if so, in which states? That's actually a pretty good question. I guess the short answer is yes, it is true. But the longer answer is it's only true in the sense that, like, in some states, some violent misdemeanors don't make you disqualified from obtaining a concealed carry permit. I think that's true probably in many states, actually, and that's true of like federal law as well. Like it depends on what the crime is, right? Because you could have, like, misdemeanor assault is technically a violent crime, but is not something that rises to the level of making you a prohibited person under federal law, for instance. And so often, in many states, you can obtain a concealed carry license, though not all states, if you have, as long as you don't have a disqualifying record similar to what federal law requires for just for gun possession, right? And so that's where the debate often comes in, or at least part of the debate around concealed carry reciprocity is gun control advocates and lawmakers from states with more restrictive policies will argue that they don't like the concealed carry rules in other states, and so they don't want people from those states to be able to carry, in their state. And so it is true that some misdemeanors, crimes of violence, don't disqualify you from either owning a gun or carrying a gun, depending on what state you're in. Obviously, I don't have a 50-state breakdown of which misdemeanors count and which don't. I would say generally my understanding is if it doesn't disqualify you from owning a gun, most states now, especially as we've gone to constitutional carry or permitless carry, Most of those states will just say if you're legally allowed to possess a firearm, you can legally carry it. Other states have more restrictive standards for concealed carry permits above and beyond the ownership of firearm. It is a real distinction, but it's probably not as controversial as it might, like in the sense that like most states I think operate that way.
Yeah, even in restrictive states like Colorado, for instance, has gotten much more restrictive in its concealed carry permitting system, and they've added new requirements and such. And they added a new requirement that says that if you have a violent misdemeanor, you're temporarily disarmed and temporarily ineligible for a concealed carry permit for a period of, I think, 5 years. They may have upped it to 10 years. But then after that, you can once again obtain a concealed carry permit with that on your record. So even in more restrictive states, you can sometimes see these cases where, in theory anyway, if you don't have something that's like a felony that gives you lifetime prohibition, you can still obtain a concealed carry permit.
Right. I mean, misdemeanors are meant to be lower level crimes. That's the distinction between a misdemeanor and a felony. A felony is meant to be a much more serious crime. And if you have any felony on your record, but at least for the moment, you cannot own a firearm at anywhere in the country. Now, obviously, there's the rights restoration process that the DOJ is finalizing now. It hasn't come online yet, but it should be online relatively soon, right? Probably next year sometime, I think is the timeline. But yeah, misdemeanors, on the other hand, are lower level crimes. And so in nearly all localities, they do not permanently bar you from owning guns, except there are some exceptions to that now. Domestic violence misdemeanors, for instance, will make you a prohibited person at the federal level for life. And so when domestic violence is added to the picture of violent misdemeanor, that does change things everywhere. But yeah, I think generally speaking, the standard in the vast majority of states is going to be that misdemeanors don't disqualify you from owning guns or carrying guns, outside of perhaps, like you mentioned, some cooling off sort of period. So yes, it is true that if you have technically some misdemeanors are violent, and most misdemeanors don't disqualify you from obtaining a concealed carry permit or carrying legally in a permitless carry state.
Yeah. Quickly, a question from an anonymous Reload member that touches on something that we just discussed, so I think we can clarify for him. But he asks if there's an anticipated time frame for a decision in Cheeseman v. Platkin, which of course is that New Jersey assault and ban case that we touched on.
Yes.
And he said, "Is there a reason to be confident that an en banc decision in favor of? Is there a reason to be confident of an en banc decision in favor of the Second Amendment, considering the current composition of the court?"
Yeah, the composition of the court is the reason to be relatively confident that, let's say at the very least, that it's a much more realistic possibility that you will see the court side with the gun rights activists in that case than in some of these other cases at the other circuits, like the Ninth Circuit or the First Circuit or Second Circuit, right? Just because the Third Circuit has a more conservative bent to it. It has a lot more Republican appointees on it, and I believe the Republican appointees are now the majority of that court. We did have the discussion of there was one particularly controversial appointment that President Trump has made this year with Emil Bove, who has a bunch of controversy from his short time at the Department of Justice before he got this nomination. And I think he was the personal lawyer for the president. And so it's sort of breaking a bit from what we saw from Donald Trump in his first term, which was much more of a nomination process that was guided by conservative legal scholars from places like the Federalist Society. And so there's concern over maybe he's going in a more personalist direction where he's just going to appoint people that he likes, and there's less emphasis on what their judicial philosophies are. And so we don't know what Emil Bove thinks about the Second Amendment necessarily. He doesn't have a track record on it that you could point to. And I think his confirmation hearing didn't touch on it. So, while he is obviously a Republican appointee, and they have traditionally for the last 20 years or so been more aligned with the conservative legal movement than, for instance, Republican appointees from 30, 40 years ago, where there's a lot of complaints that they ended up not having that conservative judicial philosophy and when they were actually on the bench. Um, we'll have to see. But at the same time, there was more traditional.
I was going to say it's difficult to parse because his other nominee, Jen Mascott, is very much of the sort of conservative legal scholar. I think she was a law professor and some Federal Society ties. So it's much more in the traditional vein. So it kind of goes both ways.
But I think the general impression of the Third Circuit right now is that gun rights activists are pretty confident that they have a good shot of winning there. And probably the best shot of any of these Sullivan's Band cases, because as we've discussed in the past, one of the real problems, going back to that point you made earlier about the Supreme Court being more inclined to decide circuit splits than just to sort of correct lower courts when they don't necessarily come down in how many of us perceive the Supreme Court would come down. One of the problems with that dynamic is most of these Sullivan's Band laws are in states that are in more liberal districts, or more liberal circuits. And so you're less likely to win a challenge to them because of the makeup of the court that you're going to be in front of. And so the Third Circuit is the first time we've seen, I think, gun rights activists be especially enthused about their chances here.
Yeah, certainly. In terms of timeline, too, I know that's part of the question. We really don't have any idea. These circuit courts can take months, sometimes years even, we've seen in the past. So unfortunately, we don't really have a good concrete answer to give you on when you can expect an opinion one way or the other.
Yeah, and it'll all depend on, as well, whether the court moves quickly. But I think that Kavanaugh time, it would probably line up with the Kavanaugh timeline that he gave, which is 1 or 2 terms, so 1 or 2 years. Maybe 3 years, which is a long time in real terms, but in court terms is not that long.
Right, it's pretty quick, right?
Yeah. Which is something to keep in mind. Like, the courts don't move that fast. They move on court time, which is slower than everybody else. All right, we got another one from Paul too, to break up the court questions a little bit. This one deals with politics. So this is every town just publicly called the Bipartisan Safer Communities Act of 2022 the most comprehensive piece of gun safety legislation ever. Is that true? How does it compare to the NFA, the Brady Bill, the Gun Control Act? And additionally, you've seen similar claims that Joe Biden was the best gun control president ever. What do we think of that?
So in terms of the Bipartisan Safer Communities Act question, I would say it's not the most comprehensive piece of gun legislation ever passed. We talked a little bit about this before we started recording today, but overall, all that law really did was, it added another category of prohibited persons, right? It closed the so-called boyfriend loophole, which has been a longstanding target of the gun control movement, of course. It added what they call enhanced background checks for 18 to 20-year-olds when they purchase guns. So they can take a little bit longer, and sales can't proceed until they've contacted state authorities to get more detailed records about young adult buyers. So that's not nothing. But the rest of it was mostly just a funding bill, funding for things like red flag law programs in various states, violence interruption programs. I think there was some school hardening measure funding in there as well.
The funding could really be used. It was, I think it was sold a lot as red flag law funding, but eventually, by the time the law actually passed, Republicans, I think John Cornyn in particular, had changed it so that the funding could really be used for almost anything school safety related.
Right. And so when you compare that to something like the Gun Control Act of 1968, which really just completely established the modern federal gun control regime as we know it by creating all these various categories of prohibited persons, and it additionally codified some of the restrictions in the National Firearms Act. It's like there's levels, I think, to when we're talking about comprehensive gun control bills.
Right. Yeah. I would say almost every one of the major gun control bills before the Bipartisan Safer Communities Act is more substantial than than that act is. The Gun Control Act, the Brady Bill, which set up the background check system, the instant background check system. The Gun Control Act created prohibited persons to begin with. The National Firearms Act was like the first one to regulate firearms in the federal level, and did so in a way that effectively outlawed a lot of firearms. Bipartisan Safer Communities Act doesn't do any of that stuff. Even the assault weapons ban of '94, even though that sunsetted after 10 years, obviously it banned the sale of lots of firearms. Certainly it's not nothing, right? As you mentioned, and it's probably the most significant of the past, I don't know, 20 years. And it's interesting because I think there's a lot of parallels with this question. You could ask the same thing about President Trump and the One Big Beautiful Bill, and it's was the first time that you've seen sort of pro-gun legislation passed at the federal level in 20 years. But is it the most significant pro-gun bill ever? No, I wouldn't say so. I don't think anybody could reasonably make that argument, because while it does cut the tax in the NFA, before that you had something like the Protection of Lawful Commerce in Arms Act. I think is much more significant. But it's not to say that, but it is the first in like 20 years. You could say that about both of them. They both were substantial legislative accomplishments in an era where you don't see that very often on guns. And now it required, I think in the latter case, a lot more maneuvering, like legislative maneuvering, because it was done through reconciliation, because they didn't have, one was passed by getting a bunch of Republicans to come on board, which has been problematic for a number of those, including John Cornyn that I mentioned earlier, among their base. But, so it's sort of a more political accomplishment, whereas the Trump was more of an accomplishment of being able to successfully maneuver through the legislative system and get what you want without having to get a bunch of Democrats on board. So different things, but both like substantial accomplishments, but neither one I would say ranks among the most significant. And then it's the same thing for the presidents themselves. Like, is Biden the greatest gun control president in history? No, because like his legislative accomplishment is not as significant as the ones we talked about before and the presidents who oversaw those. Same thing with Donald Trump. Like, you could make an argument, perhaps, they both have tried to use executive actions in a more substantial manner than some of their recent predecessors, like Bush or Clinton or Obama did. But at the same time, and Donald Trump still has 3 more years in office, so maybe he'll pass some more significant gun control, pro-gun legislation, although that's obviously very hard to see how that's going to come out with the way things are headed, both in his approval and in Congress, and the likely outcome of next year's elections. But so he still has time, and I guess Joe Biden could come back and run for another term if he wanted to. He'd be like 100 years old then, but anything's possible in this world. Look at the last few years, who knows? But yeah, I would say that it's hard to argue that either of them on their accomplishments are the most pro-gun or the most pro-gun control. Maybe rhetorically, they're both extremely aggressive in their rhetoric around the issue, much more so than their predecessors, Bush or Obama or Clinton, or you could go back and back. Bush 1, even Reagan. I would say that both Trump and Biden have been much more rhetorically aggressive on the issue, but their actual accomplishments are not as significant as some of the previous presidents out there.
Yeah, I think that's right. We got a good question from Reload member Vern here, asking about the recent spate of lawsuits that we've seen trying to attempt to remove suppressors and short-barreled rifles from the NFA, and the fact that the DOJ is actively defending the NFA in court. He said he recently heard that a Senate committee that dealt with the reconciliation bill that attempted to delist all of those things from the NFA sent a letter to the DOJ, and they explained that the Senate had tried to remove these items, but the parliamentarian wouldn't allow it. He said, it seems like this would be an obvious reason for the DOJ to back off and for the courts to agree to remove them from the NFA. What do you think about that?
Yeah, well, I think it was House
I
Republicans, right?
believe it was the House as well, yeah.
Yeah, who sent that letter, sort of trying to argue a congressional intent argument for these court cases. I don't think that's going to have much bearing because, like, you could argue that certainly some members of Congress wanted to do that and wanted to get rid of, would have repealed the NFA altogether, right? But what matters much more, I think, in these, even in originalist circles of judicial interpretation, is what Congress actually did, right? It doesn't matter as much that some members of Congress view or wanted to do more than they actually did. And so, like, yes, the parliamentarian stripped out delisting, but I mean, the Congress could have delisted if they had enough support to do that, and they just didn't. Then, so I don't see it having much weight in these court challenges that are going on. Whether it should have an impact, whether how much it should weigh on the DOJ is more of a political question, I think, right? And certainly you could go back to the whole conversation about Donald Trump and how his presidency is playing out. In some ways, he's aggressively pro-gun, like, filing the first of its kind brief at the Supreme Court supporting this challenge to Hawaii's gun carry restrictions. The Civil Rights Division filing that case against Los Angeles Sheriff's Department, or rolling back some of the ATF rules that the Biden administration had put in place. And then in other ways, they're on the wrong side of the gun rights movement. And this is one of those examples where they're on the other side of it. And I mean, the DOJ could look. There's obviously a tradition where the DOJ's job is to defend what federal laws, but there have been occasions, both under this administration and others, where they take much more restrictive views of what the law does or the constitutionality of the law, even. But they haven't done that here, and I think they would make the similar argument to what I articulated earlier, which is just that Congress didn't do the things that they didn't ultimately follow through and delist, even if that would practically happen because the parliamentarian stripped something out. It also happened because there wasn't enough political support in Congress to pass it through normal order. And so what matters most is what they actually passed. And even then, of course, then you get into the what the DOJ is arguing in court, which you wrote a recent piece on, and they're saying that the gun rights advocates aren't relying on the congressional intent. This argument that you've seen from some House members, they're not relying on that in court. They're not saying that's what makes the case win or fail. They're relying on the argument that the NFA is a tax. It's an exercise of the Congress's taxing power, and now that the tax doesn't collect any revenue, it shouldn't be constitutional anymore to have these things, the other aspects of NFA regulations applied to things like silencers, the registration requirements and so forth. And so DOJ doesn't agree with that either, though, is the, I think, more controversial bit. Like they're full on rejecting that concept outright, regardless of this whole congressional intent question.
Yeah, no, that's a great point. The DOJ, I've written about this for months now, is sort of, like you said, taking unprecedented action in some ways against state gun laws, but they have been zealously guarding their enforcement priorities, I would say, at the federal level in many of these cases. And I would expect that to continue for the NFA as well, regardless of any letter from House members.
Yeah. And I also, there was a question earlier, part of, I think Paul One's question was like, how sincere are these efforts to overturn the NFA from the gun rights activists? Do they really think they can win these cases? And I would say, yes, they do think that this is something that there's actually two different coalitions of gun rights groups filing this similar claims against the NFA after this this law was passed. And I do think they legitimately believe their argument is the correct one, that, this, look, the NFA, how is this being justified? It was always justified as a tax on these items, and that the registration involved was just meant to prove that you paid the tax. And therefore, if the tax is now $0 and doesn't serve any sort of revenue collection purpose, it shouldn't be a constitutional exercise of Congress's taxing authority. And I don't think that's like a disingenuous argument at all. Whether it's going to win is another question. I mean, that even sort of goes beyond like Second Amendment law, right? That's more tax law, and what can Congress justify a tax that doesn't raise revenue. And I think the record on that is a little less clear, right? Like, it might say, I think to a layperson that sounds absurd, right? But if you look at the case law, I think it's a closer question than maybe a lot of gun rights activists would like it to be, certainly. But yeah, I do think it's a genuine attempt. I do think they really believe in that argument. And I don't think it's some absurd argument on its face, certainly. But speaking of the NFA and gun rights activists, we have a question from Cody, who asks, why do gun rights advocates continue to focus on the NFA, assault weapons bans, and et cetera, when the biggest issue, in my view, is our right to bear arms? Possession of guns is meaningless if we can't carry them across the nation for self-defense. I get the sense that gun manufacturers are setting the priority on gun restrictions and leaving the public bearing of arms without more lawsuits and more talking points in the media. So he's sort of wondering about the current strategy that we're seeing from gun rights advocates, whether it's the right one.
Yeah, I think there's a couple of things going on there, where one is that things like the NFA, assault weapon bans, active hardware bans are longer standing sort of white whales, I would say, of the gun rights movement. Like, they've been going after them for years. They're a lot sexier. They tend to energize people that support these gun rights groups that file these lawsuits. That's why they capture a lot of attention, because you see this even when these types of measures like assault weapon bans get proposed in state legislatures, for instance, that it attracts all this attention. The Capitol becomes a circus because people pack the committee rooms and testify against it. It's a different category of gun law that really attracts a lot of passion and attention. And so I think there's a reason that there's attention paid to that. Whereas on the flip side, yes, people care about carry rights, but outside of like the 6-7 states that actively try to rebuke the Supreme Court, for instance, most of the country is fairly permissive when it comes to concealed carry. We're now at 28 or 29 states with permitless carry. The rest, the bulk of the shall issue states that do require permits tend to give them out relatively easily with relatively few sensitive places restrictions. And so I think maybe that's where some of the disconnect comes in the attention paid, was that, yes, there are states like California and Hawaii, obviously, going to the Supreme Court, and New Jersey and New York, where they actively do everything in their power to make it as difficult as possible to carry. And there are lawsuits in those states. But at the national level, people are very much concerned with those federal laws and big ticket hardware bans, is my read of it anyway.
Yeah, I mean, I think there's two things going on. One is there are far more people who own firearms than who carry firearms. So it's just a lot more people concerned about hardware bans than they are about carry bans. Although I would say, like, within the gun rights movement, among gun rights activists, you certainly tend to have overrepresentation of people who carry guns compared to the general public. And I do think that there is a lot of emphasis put on, gun carry restrictions. And frankly, if you look at politically, certainly, there's been more success on the gun carry front from gun rights activists over the last, at this point, I guess 35 years, since the 1990s, than on like things like assault weapons bans, because you see in the 90s, it was almost impossible to legally carry a gun on you anywhere in the country, right? It was very difficult. Most places had outright bans. And that all started to change through political activism more than anything else, more than legal activism, although there have been some obvious legal wins during that time period, although most of those came more recently, right? The last 10 years or so. But really, if you go back to the 90s through now, there has been a tremendous amount of political activism on expanding recognition of the right to carry firearms by just getting laws passed at your state level. The vast majority of states that got rid of their concealed carry bans did so under legal pressure, or under political pressure rather than legal pressure. Now, to get the last couple of holdouts, it took some court cases, but most of the laws were changed through the legislature over the years rather than through court cases. But so I would say that as far as the gun rights movement is concerned, they have put quite a lot of effort into expanding the right to carry, just as much as they put into fighting, maybe more so than into fighting assault weapons bans and things of that nature, or the NFA. Certainly stuff like the NFA, because it's a federal law, tends to get more discussion than your local gun carry restrictions would, just because it's something that affects everyone in the entire country. But but yeah, I wouldn't count out how much activism there has been on this front, how much the gun rights movement cares about it, because I think they do put it up there as one of their top priorities. Even when it comes to legislation, yes, repealing the NFA has been certainly picked up a lot of steam of late, but I think that was more because the nature of the NFA leaves it more vulnerable to the sort of legislative tactic we saw succeed, which is reconciliation, because you can it's a tax law, so it's a budget law, and you can do some things to it, at least through that budgetary process of reconciliation, where you don't need to get 60 votes in the Senate for it to pass. And so whereas the other top priorities like concealed carry reciprocity, national concealed carry reciprocity, is still something that you hear a lot about, but something that's hard to actually pass because it requires 60 votes in the Senate. It's not a budgetary measure. It's a piece of normal legislation. And so, but that has been at the top of the legislative package for gun rights activists for a very long time now. It's just they haven't been able to succeed in convincing Democrats to come on board, to a large enough degree to where you could realistically see it passing the Senate, even with 53 Republicans in there. So yeah, I would, for me, I do think that the gun rights movement, at least, has been equally as focused on expanding gun carry as they have been on trying to get it hardware bans in some of these states.
Yeah, no, I think those are all good points. Yeah, one more question here from Paul too, as well, related to carry. He's asking about constitutional carry or permitless carry, and he wants to know a little bit more about the details. He says, if there's no permit issued, is everyone just assumed to have the right to carry? Alternatively, does the state continue to issue permits to anyone who asks for one? If no permit is legally required within the state, do states keep issuing them if people meet the additional training and background checks under the old permitting regime? And he wants to know why, if they do, why. And then he has some questions about how reciprocity works with permitless carry states.
Yeah. So he's got a lot of questions here on how does permitless carry work, and the basic details, and it can vary a little bit from state to state, but the vast majority of them, it's actually pretty straightforward, right? The concept of permitless carry, or what most activists will call it constitutional carry, which is if you can legally possess a firearm, so you're not a prohibited person, in other words, you can legally carry it. And we've talked about this a little bit earlier in the show, but yeah, so as long as you don't have a criminal record that's serious enough to prevent you from owning a gun, you can carry that gun. You don't need to go get a permit first. And so that's the general policy. But it's actually a good question, because so what is that? Does that mean they just stop issuing permits in a permitless carry state? No, most permitless carry states will still issue a permit, and which kind of sounds weird. Like, what's the why have a permitless regime then? Well, it's mainly for the reciprocity issues that he brings up, because most states that require a permit to carry, they will not accept just the status of somebody being from a permitless carry state. Most of them will want some sort of actual permit from your home state in order to recognize your ability to carry in their state. And so that's why you will still see many permitless carry states issue concealed carry permits. Some of them also have like age requirements where like permitless carry is only good after a certain age. And so you still have to get a permit if you're under that age. If you're an adult but you're not 21 or 25, you may still have to get a permit to legally conceal carry in that permitless carry state in some of them. So I mean, it's a good question about the practical side of it. But yes, most states with permitless carry laws still issue permits to people who want to be able to carry outside of the state, because many more states will recognize your ability to carry if you have a permit. And if you don't, I mean, this goes back, becoming less and less of I think, practice now that concealed carry laws have liberalized so much in the United States. But a lot of people will go and get multiple permits from multiple states because the way, without a federal law governing any of this stuff, which is, again, goes back to what we were talking about in the last question. That's one of the proposals that gun rights advocates want from Congress, is a national reciprocity law. What that looks like has changed a little bit over the years, and actually had a totally new proposal this year, which we had Rep. Hudson, who's the main sponsor of that legislation, was on the show actually to talk about it a while back, but you can go and look up that interview if you want more details on the latest proposals. But the gun rights activists want a national law that makes every state recognize each other's permits, because right now what you have is just a sort of a patchwork where some states recognize some states recognize all states, like Virginia, for instance, has a universal recognition. And then some states don't recognize any states, like, New York or California or Washington, D.C. They don't recognize anyone else's permits. And so, but, within that mix, some states will, some states that recognize some states, they might recognize a permit from Utah, whereas they don't recognize a permit from, South Carolina or something. You have to look these things up. Not speaking to an actual literal example, but I know that the Utah permit was one that people used to get the non-resident version of in order to be.
I have a Utah.
There you go.
I could speak to that. I have a Utah non-resident permit, exactly because it gives me 2 additional states that Colorado isn't recognized in, and one of them being a state that I visit frequently for family reasons. So I got the Utah permit.
There you go. But yeah, so it's kind of a patchwork. And if you want to carry outside of your home state, even if it is a permitless carry state, you're probably best off getting whatever permit they offer, and maybe even getting a Utah. And this will often come down to, we talked about this a little bit earlier, where yes, some states will, I think most states will, you could still qualify for concealed carry permit, even if you have a violent misdemeanor on your record, depending on what that misdemeanor was. But not every state will do that. And some states require a certain level of training. Some states don't require any training to get a permit. Pennsylvania doesn't require any training to get their permit. You just have to pass their background check. But yes, so some states also have different, like I remember there's a dispute between, I have a Pennsylvania non-resident permit because Pennsylvania specifically looked at Virginia and said, we're not going to recognize your permit. And it was a dispute over like how available the Virginia state police database is to other states, that Pennsylvania wanted like a 24-hour availability to run checks on people's permits, I think it was, and they weren't available 24/7. So that was one of the reasons given for why Pennsylvania would no longer recognize Virginia. And that personally, it's just like you with the Utah thing, that personally meant that I had to go get a Pennsylvania non-resident permit because they wouldn't recognize my Virginia one. I have a DC concealed carry permit because they don't recognize anyone else's permits, so on and so forth. So it's kind of it's a patchwork, but yes, that is why you will see permitless carry states issue permits, because people want to be able to carry outside of the state, and many states require you to have a permit to do that. So Yeah, I think that's all we've got. There's one bonus question here from Reload member Mike Williver. I will give this full name here. He asks, what is your favorite podcast and why is it the Active Self-Protection Podcast? So, yes, I do love the Active Self-Protection Podcast, actually, although I prefer what we call the Gutowski Files, which is my my podcast that I do with Mike over at Active Self-Protection. Actually, the full podcast as well, the interview podcast that they do is fantastic because if you know anything about active self-protection on YouTube, they analyze real-world self-defense incidents or police shootings or badge cams, things of that nature, and they give you, real-world training advice based on what actually happened in the video, which I think is a pretty good, a pretty smart approach. But then they also have this podcast that Mike hosts where they interview people from those videos, right? They'll go out and find the people who were in some of these shootings or self-defense encounters or what have you, and they will actually interview that person about what it was like, which I think is a great supplement to the videos that they do, the very popular videos they do on YouTube. And then we do a little news podcast together, similar to our news update here at the Reload. But yes, go and check out the Active Self-Protection Podcast. We did an ad for the Reload at the beginning. There's now to an ad for Active Self-Protection at the end. And he asked a follow-up, which is Mike as dreamy in person as he is on the show. And having met Mike once in Las Vegas, was it Indianapolis? Very different from Las Vegas. Yes, I would say yes. That's my answer. Very dreamy Mike in real life if you ever get to meet him. But yes, check out the Active Self-Protection Podcast as well if you haven't before now. But I think that's all we've got for this episode. It went a little long, but it's kind of 2 in 1. So hopefully we answered every question. So we didn't get to every single question that everybody sent in, but we got to most of them. So I'm happy with that. And yeah, hopefully you have some fun Thanksgiving plans coming up here. Jake, spend some time with family, I assume.
Yep. Spend time with family, watch some football, eat some good food. I love Thanksgiving. It's one of my favorite holidays, so I'm looking forward to it.
It is great. I have the Eagles play on Friday, which hopefully will erase all of the memories from last week. They
pretend that didn't happen. Yeah,
freaking Cowboys. Oh, that was awful. But yeah, so I don't know if I'm looking forward to it, but they will be playing. I'm looking forward to Thursday, not as much Friday, but hopefully they can turn around and make me less depressed about what the heck they're doing right now. But yeah, I think that's all we've got, right, for this week. And we will see you guys again real soon.
No, the devil's got no